to all of our participants and our wonderful and esteemed panelists. My name is Tahira Amatul Wadud. I'm the Executive Director for CARE Massachusetts, and I am beyond excited to be in the room, the virtual room, with these incredible activists and advocates looking to help shape and protect the rights of citizens, students throughout the Commonwealth who have been activated over the past 4 months on the issue of human rights. I introduce myself along with our legal director, Attorney Barbara Dugan, and our wonderful youth director, that is Fatuma Muhammad. We are very excited to have in a partner National Lawyers Guild and wonderful members of the community doing this advocacy work. There will be other further introductions, so I will not belabor that, but I just want to tell you that CARE Massachusetts is a nonprofit organization, and our chapter is very focused on protecting the civil rights and civil liberties of Massachusetts Muslims here throughout the state. I hope that you all enjoy the evening and learn a lot. I'm looking forward to doing both. Thank you.
Thank you, Tahira. Good evening and salam alaikum. My name is Barbara Dugan, and I am the legal director at CARE Massachusetts. Again, I want to make sure we acknowledge Fatuma Muhammad, who's the brains behind the scenes tonight and is making all of this actually happen. Thank you again, Fatuma. As Tahira mentioned, we are so pleased to co-sponsor this event with the Massachusetts chapter of the National Lawyers Guild. I'm proud to say that I've been a member of the Guild since law school back in the 1970s. For those of you who aren't familiar with the Guild, the Massachusetts chapter is the local chapter of a national organization of lawyers, legal workers, jailhouse lawyers, and law students. The National Lawyers Guild has been the legal voice of every progressive movement to rise up against oppression and government repression since it was founded in the 1930s. Currently, Guild lawyers are at the forefront of those providing legal support for pro-Palestinian activists. They do so on a volunteer basis in addition to their day jobs. So on to the program. We arranged the order of speakers tonight based on the chronological order of how events are most likely to unfold. So we're going to start out with Jeff is going to talk about legal rules and practical tips for demonstrations and protests. And then second, Mason will talk about social media and doxing. Third, Naomi will talk about student disciplinary hearings when the school is taking action against a student, and often the result of something involved in those first two topics. And then fourth, Anika is going to talk about tracking these disciplinary hearings so we can compare notes and have a better understanding of how schools are handling these matters. And then finally, Christina will talk about U.S. Department of Education civil rights complaints, which is the flip side of the third topic, when students take action against their school. After that, we will open it up for your questions, but as the program progresses, please submit them through the chat function, and then tell us if your question is directed to a particular speaker. So moving on to our wonderful speakers. For each of these speakers, we will be giving you a link to a more comprehensive bio, because it would take far too long to tell you just how great they all are. We will at least give you a short introduction for each person, starting with Jeff Feuer. Together with his law partner, Lee Goldstein, Jeff has had a community-based law practice for nearly 30 years, concentrating on representing tenants, employees, political demonstrators, consumers, and community-based nonprofits. He has also been an active member of the National Lawyer Guild's Massachusetts chapter for more than 35 years. As part of the Guild's Mass Defense Committee, he has coordinated free legal defense for demonstrators arrested during actions for a wide variety of progressive causes, and often represents them in court as well. Now, if you've seen the Guild's legal observers at protests, those folks in the lime green hats, odds are good that they were trained by Jeff. Most recently, he has been active with students and faculty facing disciplinary actions for their participation in nonviolent demonstrations in support of the Palestinian people. Jeff, take it away.
Good evening, and very happy to be here. Very happy that everybody is participating in this. So what I'm going to talk about is two things, sort of how to prepare practically for participating in a demonstration where you might face arrest, and to be aware of what, if you are participating on campus, what kinds of things you need to look out for. For any demonstration, it's really important that you prepare in advance for it. When you're deciding what demonstration to do and how to do it, you are in charge. You're going to get to decide when and how to participate, where to go, what to say, when to leave, and so forth. But if you get arrested, you lose most, if not all, of that control. Essentially, you're now playing in the ballpark of the police and the legal system and under their rules. You'll be told when and where to show up, when you are allowed to speak and to whom, whether or when you can leave, and what the rules are for your behavior. You can always challenge those rules or refuse to obey them, but the consequences for doing so can be severe. Therefore, if you have the opportunity to make a choice about getting arrested, which not everyone has during a protest or a demonstration, it should not be done impulsively, but should be a carefully considered political decision on your part. So, in terms of demonstrations on campuses, those demonstrations are going to have special rules, and it behooves you to take a look at your student handbooks and look at what the rules are for protests or demonstrations on campus. Every university in the greater Boston area has a section of the handbook. If it's a big university, they may have separate handbooks for different colleges, for undergraduates, for graduate schools, and so forth. So it's really important to take a look at that, see what the rules are for behavior, conduct, and most of them have a separate section on protests and demonstrations, what's permissible and what's not permissible. It doesn't mean that you have to abide by all of those rules, but it does mean that you may face disciplinary actions if you don't abide by them. So that's a choice, again, to think about and make before you do the demonstration. Are we going to break some of these rules? Will that advance our cause? Will that help bring attention to what we're doing? Or is it just going to get us in trouble for no purpose about that? It's particularly important. The one key thing that I want to talk about before I get into some of the practical tips is if a person is not a U.S. citizen. So the U.S. Supreme Court has held that the government can target non-citizens because of their engaging in lawful First Amendment activities. The U.S. Patriot Act of 2001 targeted certain speech and association activities by non-citizens. And under the Patriot Act, non-citizens could face deportation for fundraising for, providing support to, or associating with groups deemed to be terrorist organizations by the U.S. government. That consequence does not apply to U.S. citizens. A conviction in the U.S. for protest activities can have serious consequences for non-citizens, including deportation or exclusion the next time you try to enter the U.S. It can also harm your chances of obtaining lawful permanent residence or citizenship in the future, and negatively affect your ability to get or keep a student or work visa. So we want to emphasize that activists need to recognize that the U.S. government is generally very hostile toward non-citizens, and you are particularly vulnerable. So if you're going to engage in a demonstration where you might risk arrest, you should talk with a lawyer beforehand to see what your status is and to see what consequences you might face. That doesn't mean you should not participate in demonstrations. Lots of demonstrations do not involve people risking arrest, and you can certainly participate in that, and you will have protections for doing that. But if there is a possibility of arrest, please talk to a lawyer beforehand if you are a non-citizen. So again, thinking about planning for a demonstration and thinking about planning to be as part of one, you want to do things that will minimize your possibility of getting arrested or minimize the consequences of you getting arrested afterwards. So, for example, you must think about the use of social media beforehand. Don't post specific information about any direct action where you might risk arrest on any social media sites. You can post general information about it, and you can post, dates and times and so forth. But specific information about what you're planning to do, or who's planning to do what, or who the organizers are, or the names of specific people, you should not do. Law enforcement agencies continually monitor social media, and they can and will use that information to, one, disrupt planned protests before, and two, to bring criminal charges against protesters. Similarly, following a protest, you should be extremely careful about posting pictures or information on social media that would allow law enforcement to identify particular individuals against whom they may seek to bring criminal charges. On campuses, this could lead to disciplinary actions against students who may not have wanted to do anything more than chant or sing or be involved in a protest. So be very careful about what you're posting on social media, both before and afterwards, so that it does not aid campus police, campus administrators, police officers, law enforcement agencies from identifying particular individuals engaged in particular actions. People holding up signs, people who have their faces covered, backs of people, demonstrations from a long shot, all of that is acceptable, but be careful and review it carefully before you post it. Similarly, live streaming is generally not a good idea for this, unless you're just going to focus on maybe a main speaker at a particular demonstration, because you do not want to put other people at risk who are participating in it. If you plan to risk arrest, or you think that you may get arrested at a demonstration, and you want to be processed and released as promptly as possible from the police station after you get arrested, there are certain things you should bring with you and certain things you should not bring with you. So bring with you a photo ID. You should have water with you, because if you do get arrested, it is likely that you will be held in the police station for many, many hours. If you get arrested in Massachusetts, you will need to bring $40 in cash, or to have somebody who has $40 in cash for each person arrested come down to the police station with that money after you get arrested. And the reason for that is how you will get released from the police station. You will have to pay a fee, not bail, but a fee to a bail commissioner who will guarantee that you will show up for your first court appearance. And that is a $40 fee in cash, which you will not get back. You should have the phone number of a lawyer or an organization that can provide lawyers. The Guild operates a hotline at times when there are mass demonstrations, and at other times when there are a lot of demonstrations going on. You can always call the hotline and leave a message on there so that we can get in touch with you and help provide either jail support, support at the police station, or representation at your first court appearance. The Guild hotline is 617-433-8353, and you can always use that. So two things that you should also make sure that you are well hydrated and that you've eaten. Again, if you're arrested and held in a police station, you're going to be there for many hours because the booking process takes a long time. If you have medications that you need, if they are prescription medications, you should carry them in the original container with the prescription label on it. If you have non-prescription medications that you have to take, you should give them to a jail support person and not have them on you, because the police may use that to bring bogus charges against you. They may hold you longer. They may treat you differently if you are carrying drugs that they can't identify. You certainly should not carry anything that can be construed as a weapon. That would include a pocket knife, a screwdriver, a wine opener, anything that is sharp or that could be construed by the police as a weapon. And of course, you should not carry any illegal or non-prescription drugs. And remember, marijuana is legal in Massachusetts for use, but it is still illegal under federal law and can be used to bring a charge against you. Okay, cell phones. This is very important. If you plan to risk arrest, I strongly advise that you do not have your cell phone on you. If you need a cell phone, bring a burner phone. And the reason for that is that the police will confiscate your cell phone when you get arrested, and they will try to gain access to it, even though it is illegal for them to do so. In 100% of the cases of people that I have represented over the last 25 or 30 years, the police have tried to get into people's cell phones. When they do that, they will download all of your contacts, your messages, your emails, and other private information. And they will use that to build dossiers and files on people who were not involved in the demonstration, and will use that also to bring charges against people on conspiracy charges who may not have actually been there at the demonstration. After the Patriot Act was passed, fusion centers were set up around the country where police agencies, law enforcement agencies share information with each other. In Massachusetts, we have two of them, one in Maynard and one in Boston, called the Boston Regional Intelligence Center. And that information is run by the Boston Police. That center is run by the Boston Police, but it shares information with the Department of Homeland Security, the FBI, local police agencies, campus police, state police. And the information from your cell phone will go into a database there. The Guild is currently suing the BRIC, the Boston Regional Intelligence Center, because they are keeping information illegally that they are not supposed to keep. So if you bring yourself, the other reason is even if they can't get into your cell phone, you may get it back accidentally broken. Oops, we dropped it. Sorry, didn't mean to. I'm really sorry, but it's broken. And you will have a hard time getting any compensation for your cell phone being broken because it was an accident. In addition to which, if you're bringing your cell phone, even if you're not planning to get arrested, because people do get arrested without warning at some of these demonstrations, please disable the thumbprint or facial recognition and put in a 6 or 8-digit password. You can change it back later. The reason for that is that the police can force you to use your thumbprint or facial recognition to open your phone, because that is not considered testimony against yourself. But they cannot force you to give up your password. And they have machines to open the cell phones, but an 8-digit password will take them more than a day to try and open, even with the most sophisticated machines they have right now. So you can always use that and change it back later. When preparing for the demonstration, again, planning is important. What you want to think about beforehand, because again, getting arrested should not be necessarily the goal. The goal, if you do get arrested, it's something you want to do in advancing your cause, in advancing the message that you want to give by a demonstration, through the demonstration. So think about what the overall goals of the group are, and will civil disobedience or getting arrested actually help to achieve those goals? There are times when the answer to that is yes, obviously it will. But that should be thought about and decided beforehand, not impulsively at the time, if you have a choice. Sometimes, obviously, the police arrest people, whether you want them to or not. You want to think about, if you do get arrested, are you able to work within the significant constraints imposed by the legal system? You will have to have court appearances, bail conditions. Many times after the arrest, your charges will go on for several months before they are resolved by a plea agreement. If you decide that you need to go to trial to fight the charges, you have to understand that trials will not take place next week or next month. This is not television. It's not a drama on TV. Trials are going to take place, given how backed up our court system is, at least 12 to 18 months after you get arrested. And you need to think about how that will impact your ability to do other things, other progressive things, continue to be in demonstrations, and continue to push forward your goals. It's also important to think about what the target is for your activities. If it is the U.S. policy in Gaza calling for a ceasefire, remember the campus police or the police who are arresting you, they don't make that policy. They are enforcing the rules of the college, or they're enforcing the laws of the state, but they're not the ones making policy in Gaza. So you need to think about who the target is for your actions. You also need to think about beforehand how much you will cooperate with the police and the court system. That is, will you tell your real name? Will you identify yourself? Will you, when you're getting arrested, cooperate with police commands? Will you allow yourself to have handcuffs put on or resist it? If you resist or you don't cooperate, there are consequences to that. You could be charged with an additional charge of resisting arrest. Lastly, you should think, well, not quite lastly, but you should also think about how much you want to talk to the police about the demonstration. Please never discuss the specifics of what has occurred. Be aware that the police, the campus police, no matter how nice they are, no matter how sympathetic they may appear to be, they are not your friends. They are trained to get information from you. And sometimes they do that by being nice and saying, we support you, and, oh, this is great. We're glad you're standing up for human rights, and et cetera, et cetera. They are going to use whatever you say against you. This is the Miranda warning that people get. Anything you say can and will be used against you. On the other hand, talking about your overall political goals and ideology can be useful in some situations, but in general, it's not wise to talk to the police after you've been arrested. One of my fellow defense lawyers in the Guild has a great saying, which is that you can never talk your way out of an arrest, but you can always talk your way into a conviction. And it's important to keep that in mind. Think about whether you need legal observers for a demonstration. The Guild has a program of trained legal observers who are there to document misconduct by the police or counter demonstrators or school administrators. And think about whether you need that. If you do, call the Guild's office and as much in advance as you can, and we will try to arrange to have legal observers there. It's a free service, and we're there to protect your rights. And last but not least is be aware that you already are all aware of this, that some people face greater risks in participating in an action or risking arrest. Non-citizens, people of color, people under 18 years old, people who have a disability or a condition that requires medication, people who are gender non-conforming in some ways, people who have prior criminal records, people who are out on probation or bail in other cases. And that doesn't mean that you should not participate. You certainly can, but think about the fact that you may face harsher consequences, harsher treatment from the police if you do get arrested. And you might want to take a lesser role or put yourself less at risk for getting arrested during a demonstration. Last but not least, I guess, when you get arrested, so an arrest is when you are going to be physically detained, whether the police officer says you're under arrest or not, but you're being physically detained, unable to move away. If you feel that a police officer is questioning you, or and that includes campus police, you can ask, am I being detained or am I free to leave? If the answer is that you're not being detained, you can refuse to answer questions and you can calmly walk away. At any time, both before and after arrest, you are free to tell the officer that you don't wish to speak to them any further or answer any other questions. After arrest, usually the only thing you have to answer is identifying yourself. You can refuse to do that, but the chances of you then getting released on bail from the police station are slim and none. But if you identify yourself, that may be the only question that you will really have to answer. However, be aware, the police don't like the fact that people assert their legal rights. And if you refuse to answer questions, they may consider that to be provocative and arrest you. So you have to make a call, a decision in your mind as to whether or not you will answer those questions, or you can refuse and say, I don't wish to talk any further, depending upon the situation and the police officers you're talking to, as to whether or not that will annoy them to the point that they want to arrest you. When you get arrested, you're going to be patted down and your body is going to be searched for weapons or drugs. You can ask for the same gender officer to conduct the pat down, although this will probably not be honored. When you're being transported after you've been arrested in a police vehicle, the police will often offer you a stick of gum, water, a soda, or even a cigarette. Do not accept it. This is a common ploy by the police to collect DNA samples, because once you leave that behind, they can get your DNA from that. And last but not least, two things. If you require medical attention, either because of a pre-existing condition or because of police conduct during the arrest, you must repeatedly and loudly make that fact known to both the police and any supporters who are around there. Stop it. You're hurting me. You're twisting my arm. That hurts. Stop it. Over and over again. That can help you fight the charges later on. Last but not least, there are the Miranda warnings that you will get. and you've all heard them. You all know what they are. Anything you say can and will be used against you. You have the right to remain silent. You have the right to a lawyer and so forth. No matter how perfunctorily those are given to you, pay attention to them. If the police don't give you a Miranda warnings, it does not invalidate the arrest. It only means that they can't use anything that they question you about that you say against you in court. It does not mean your arrest will get thrown out at all. So pay attention to the Miranda warnings. They're there for a reason. Use them. You have the legal right not to answer those questions. And the Guild will be there to help you fight any charges. We'll be there for arraignments, and we'll be there to help represent you in court. Those are my tips.
Great. Thank you so much, Jeff. I mean, enormously. Our next speaker is Mason Courts. Mason is a National Lawyers Guild member who works at the intersection of technology, law, and social justice. Excuse me. He teaches at the Cyber Law Clinic at Harvard Law School, where he supervises law students as they provide free legal services to clients across the country. His areas of interest include online speech and privacy, anti-surveillance work, and government transparency. Mason, thank you so much for joining us this evening. And
Thank you so much. Yes, I got the message. Thank you so much for having me. I am very excited to be here. So I wanted to talk a little bit about and expand a little bit on what Jeff said about social media. So I'm gonna really quickly cover 3 topics. So helpful and potentially harmful uses of social media in the pre, during, and post demonstration. What you can do about personal safety in terms of social media and your online presence to minimize harassment, and then this, really pernicious issue of doxing. So just to back up what Jeff said, pre-demonstration, the biggest risk with social media is giving too much information. And I know that that can be a bit of a tension because you want to publicize your direct action. You want to have people show up. Social media has been a great boon for organizers in terms of reaching people, who you may not have a direct personal connection with. But too often I see people posting questions on social media, like, in response to a Facebook post or on Twitter, asking for things like the route that a march is going to take, or planning strategy around what are we going to do if the police tell us we have to stop. Just anything that's taking place on social media, even in a private group like a Facebook group, you should assume that the police and potentially the school administration are privy to that. Typically, in large groups, there will be at least one police officer with a fake profile who has managed to get into that group. If you're going to be planning specific strategies around an action, I highly recommend doing that in person, or at the very least using some sort of secure messaging technology like Signal, rather than relying on social media. During a demonstration, as Jeff said, again, people often want to take pictures, they want to document those pictures, but you're potentially generating evidence, especially because evidence could be stored on your phone, which, as Jeff said, police may try to look at. But if you put it on social media, it's actually pretty easy for the police to go to a social media company to try to pull pictures, even if you've gone and deleted them afterwards, because the warrant is then not directed at you, where you would have an opportunity to move to oppose it or exclude the evidence, but directed at a social media company who is unlikely to intervene and assert your, assert your privacy rights. Same thing for post-demonstration. Obviously after a demonstration has happened, descriptions of what happened, what route was taken are less sensitive. But again, be very careful about naming names, about posting pictures, about providing documentary evidence of who was there and what they did, because even if nobody was arrested in an action, that does not foreclose the possibility of later disciplinary action by the school. Whereas arrests by police often happen during a direct action, letters of disciplinary action may come, days later. The protest may feel like it went off without a hitch, only to find out later in the week that you and your fellow students are facing disciplinary action. So just because the action is over does not mean it's fair game to post all your photos or tag all your friends saying that you were at this protest. Keep in mind, trying to balance the need to inform people about the action while not providing specific strategic information, names, photos, or other identifying information about the organizers. But the other thing I wanted to talk about a little bit was sort of personal safety when it comes to online presence and harassment. This is something that is not you're not likely going to be facing from the police or your school administration, but from unknown third parties out on social media, which is if you take a position on social media, if you indicate that you were involved in a protest action, if you express support for that protest, you have one of the many possibilities, one likely possibility is that you will be targeted on that social media platform through harassment. And there are many levels of that. And well, I would say that this is an area where law enforcement and school administrators are often not directly causing the harm. They are very, very unlikely to be helpful. My experience, especially in the last few months, has been that law enforcement and law enforcement for years have not taken online harassment seriously, and they're even less likely to take it seriously when it is targeting a minority, a minority person of color, person with a controversial viewpoint that is expressing that in public. I would not expect legal protection, and I would not even expect much sympathy or protection from your school administration. I have seen a lot of very blandly worded statements expressing concern for students' well-being, but personally, I've not seen administrations taking actions to actually protect their students. So protecting yourself on social media really is something that you will have to do for yourself and for your companions in these protest actions. So one thing I want to say about this is that this is a situation where an ounce of prevention is worth several hundred pounds of cure, in that once you become the target of a coordinated harassment campaign, it is very hard to stop that. It is possible sometimes to get social media platforms themselves to take down harassing posts. However, typically, I would say with certain social media platforms, those owned by Meta, so Facebook and Instagram, they are not good, but they are the least bad in terms of taking down harassing posts. Twitter, 90% of their trust and safety team was recently fired within the last year. They have almost no moderation. Those posts go unchallenged. But the real concern is when your Twitter handle or your Facebook account, or hopefully not this, but your email, gets onto one of these websites that is really geared toward coordinated targeted harassment campaigns, right? So one of the best known ones is Kiwi Farms. They engage in targeted harassment of people supporting LGBT causes. And they exist to find people, find their contact information, and make sure that they are continually spammed with death threats, other threats of harm, threats to contact their employer, threats to contact their school. Once that process starts, it is very hard to intervene because that information is generally in hands of people who do not care about your well-being. And any plea to have them stop or take down your information is only going to encourage them. So the question is, what can you do ahead of time? So before you engage in a direct action, I recommend at least temporarily locking down your social media account so that only people who you have a friend connection or mutual following connection on Twitter can see your content. You may also, just for your own personal sanity, want to, where possible, block off any DMs from people that you do not have, kind of a personal connection with. And you probably also just want to be careful about screening the people who are sending you friends requests. Oftentimes, the way that bad actors, whether they be governmental or not, get into these groups and infiltrate these groups is by sending a friend request that they just are hoping someone does not look at too closely, and then invites them into the group where the planning for the action is taking place, where the strategy is taking place. So just be very careful about that in the days leading up to a direct action. In terms of harassment, the types of harassment that are very common for people are either communications through direct messages or email that might contain some sort of threat. It's also public postings, encouraging other people to dogpile someone, and then potentially even contacting employers or future employers. This has been a big concern at the law school where I work, where students who've expressed solidarity with Palestinian people are getting their employers, their future employers, the law firms that they're planning on joining, are getting flooded with emails saying, "Don't hire this person." So to avoid that, locking down your social media before direct action, locking down your direct messages, and also doing what you can to ensure that there is not easily visible information that would allow someone to connect your picture with your identity. And this kind of gets into the last topic I wanted to address, which is doxing. So doxing is revealing someone's personal information, often their identity, their place of residence, or their contact information online in a public way, usually with the goal of getting people to then coordinate a harassment campaign against them. Doxing unfortunately has been extremely prevalent in the last several months on various university campuses. It is emerging as one of the most kind of prevalent and frightening techniques that is being used against students, especially students who are expressing solidarity with the people of Palestine. And again, once this has happened, it is often difficult or impossible to get that information taken down, because the people who are posting this information, who are making it publicly available, do not have your best interests at heart. So again, what you want to do is, what can you do prophylactically to prevent this? So one is, look through your recent posts and see, do you have posts that could allow someone to figure out where you go, where you live, what dorm you're in, maybe your home address. I've often seen people get doxxed because they have a picture up on Twitter publicly that says, "So happy to be home for spring break," with a picture of them with their house in the background. And someone can zoom in and see the mailbox number or something like that. It can also be less of a direct connection. So some of you may be familiar with the case of Andrew Tate, who is this really awful person who was essentially hiding from charges from the Romanian government of rape and sex trafficking, and was busted because he posted a video. And in the video, you could see that there was a pizza box on his table, and the pizza box was then connected with a very specific pizza place, which allowed the authorities to figure out what town he was in. So people who want to find out who you are will go through great lengths. There are people out there who really have nothing better to do than to go through your entire social media history, trying to figure out where you live, where your parents live, where you work, what your email address is, finding some way to escalate this campaign against you. Again, taking a prophylactic view, going through your social media, locking it down so that only friends can see your posts, going through your public posts and making sure there is nothing that outs your location or the location or identity of your family is extremely important. There are a couple services you can use that will help you with this. One is called Delete Me. Delete Me will help you scrub your information from online data brokers. This is mostly helpful if someone gets your name. It will prevent them from learning other personal details about you. Data brokerage sites have just like vast amounts of personal data on individuals, including their email information, their last known address, their phone number. By using Delete Me or a similar service ahead of time, you can minimize the chance that someone will be able to connect your name with more intimate personal details. The other, sometimes doxing escalates into more aggressive hacking and impersonation, where a targeted harassment campaign will involve someone actually trying to get access to your accounts, your social media accounts, so that they can post things posing as you, and that will often serve to escalate harassment. If you feel like you are at that level where you are where a harassment campaign is escalating into active hacking, there's a really great website called Tall Poppy that provides some resources for people who are facing that level of kind of coordinated harassment. But yeah, to sum up, social media management, both in terms of protecting the action and the movement and in protecting yourselves, is all about prophylaxis, and it's about minimizing the exposure of information, because once that information is out there, you're going to have a lot of trouble clawing it back in. So, just, do the preparation ahead of time, and hopefully it will save you a lot of headache and heartache after the fact.
Thank you, Mason. I mean, that was both fascinating and terrifying. So we appreciate you sharing your expertise with us. Thank you so much. Our third presenter is Naomi Shatz. Naomi is a partner at the law firm of Zalkine, Duncan, and Bernstein, where she represents students and faculty members in employment, disciplinary, and education cases. Her practice includes representation in internal school proceedings, dealing with free speech, discrimination, sexual misconduct, and other alleged violations of school policies, as well as litigation against schools, colleges, and universities to enforce student and faculty rights. Naomi, thank you so very much for joining us this evening.
Thank you, NLG and CARE, for having me. So I am here to talk about school disciplinary procedures, which is what happens if you engage in a protest action or many other kinds of action, and the school decides that it thinks you violated its policies. And I'm going to repeat something that Jeff said earlier, which is because these processes vary from school to school, and really every single school has a slightly different way of handling these things. The most important thing you should do as a student or a faculty member is read your school's policies and your student handbook to understand what actions are prohibited, how your school defines different terms, and what the process is if you are charged with a disciplinary violation. So in terms of a legal framework, there is a difference between the rights that you will be afforded if you're at a public school versus if you're at a private school. So if you're at a state school, public university, you're entitled to due process, which really just means notice of what you're being accused of and an opportunity to be heard. But courts have given a lot of interpretation to that, so you have a slightly more protection in the process than at a private school, where basically what you're entitled to is whatever's written in the school policies, as long as those policies are seen to be basically fair, is the term. And that term has not been super well defined in the courts. So you will get a little bit more in the way of procedural protections at most public schools. In terms of the way these cases go, you will usually receive something in writing from the school saying that you are being accused of violating some provision of the student handbook, and you will be told what the next steps are. Often these cases start with a meeting between you and an administrator where they present you with the information they have, or at least the charge, talk you through what the process looks like. Some schools may expect you to respond verbally right there in that meeting to the information you're being provided. Some may have a whole process where that first meeting is just the informational meeting where the school gives you, tells you its plan and what's going to happen, and they don't expect a response right then. You know, obviously, it is always a good idea to take time, think through what you're going to say. And so even if you're in a meeting with an administrator and they say, okay, well, here's what we've got. We got this report that you were sitting in at such and such building and you didn't leave when you were asked, and that violates this rule. What do you have to say? It's always fine to ask and say, I'm just getting this information now. Can I please have some time to look at what you've given me, look back and see if I have any relevant information to share, and then provide you with a response. The worst that happens is they say, no, this is your one shot to give us a response. And then you at least know that you have to say something then, or forever hold your peace. Usually they will let you take some time to put your thoughts together. Some schools do ask you to provide a response in writing to the information you're given. Some give you information and then call you into a hearing later where everything is done more orally. Some schools hire investigators to conduct an investigation into the allegations and interview each witness and each person involved privately, and then put together a report that you may or may not have a chance to respond to. So the processes are really different, and it's important for you to know before you start down the path of engaging it, what is going to happen. Generally, students can have advisors during these processes, and generally those advisors cannot be lawyers. In the Title IX context, when you're dealing with sexual harassment or sexual assault, schools have to let you bring a lawyer because of federal regulations. In all other kinds of cases, they don't. And so they do not want lawyers there because that makes things more difficult for them. So it's usually they limit it to someone from the school community who can come with you. So you can choose someone that you're comfortable with, a professor, an administrator, a coach. You know, you could probably try bringing in a law professor if you have one that would help you out if they're a member of the school community. But you definitely want to have someone there with you as an advocate. Even though they're generally not allowed to say much in those meetings, having them there to take detailed notes, because these meetings are often not recorded, and you don't want to rely on whatever notes the school that is investigating and prosecuting you is taking. So having someone there who could just take detailed notes of what's happening and what everyone's saying, who can know what, help you, remind you of things you wanted to say or information you wanted to give, and just be there as a support person. It's really important. So to prepare for a disciplinary process, obviously the first step, read the handbook thoroughly, make sure you understand what behavior the school can punish and what it can't. If you're not clear what you're being charged with, you have a right to know what they're accusing you of. So you can go back to them and say, this isn't clear to me. What provision are you relying on? What behavior did I engage in? And see if they'll give you more information. And then you need to figure out what your arguments are and what evidence would support those arguments. So, it's a good idea to write down just for yourself, not necessarily to hand over, but your most detailed memory of everything that happened as soon as you think there might be an issue, so that you don't forget what happened. And then think through, do you have text messages that will help? Do you have photos or videos that might help you? And as we've heard from other people, sharing those kind of things may have consequences for other people that are shown in the photos and videos. So you need to think through, what you need to do to protect yourself in this process, and how that will impact other people. Is there location data on your phone that could be helpful to show where you were when? I mean, if, for example, you're being charged with engaging in some action that you weren't actually at, proving that you're not there is key to key to your defense. And then do you have witnesses, people that were there with you, people who could speak to what you did or didn't do. Those are people you're going to want to tell the school about so that they can interview them in the process or bring them to a hearing. And so even though lawyers aren't allowed to be your advisor in these proceedings, there's nothing that stops you from hiring a lawyer to help you prepare or identify legal issues that might arise. And if you do have legal issues, if the school is violating the rights that you're given in the handbook or the rights that you have under law, a lawyer might be able to interface with the school's lawyers and try to address those situations and rectify that. But schools do not provide you with these lawyers, so that is something you would have to go out and do on your own and at your own expense. If there's a potential for there to be a criminal proceeding arising out of the incidents as well as a disciplinary proceeding, I would strongly urge you to talk to a criminal defense lawyer before participating in the school disciplinary proceeding. At our firm, we are both criminal defense lawyers and school lawyers, but we often see that there are school lawyers who advise students without thinking about whether what they're telling them to do could harm them in a criminal case. And as Jeff mentioned earlier, your Miranda warnings, anything you say in a school disciplinary proceeding can be used against you and will be obtained by a district attorney in a criminal prosecution. So there are times where your strategy in a criminal case, where the Commonwealth has the burden to prove beyond a reasonable doubt that you did something, your strategy may be, they don't have enough information. If we don't give them any information, they can't meet their burden. Whereas your strategy in a school case where the standard is the school just has to find by a preponderance of the evidence, which means just slightly over 50% leaning in favor of you violating a rule, your strategy may be different, and you have to weigh and decide whether to participate in the school disciplinary proceeding. And if it is going to negatively impact you in a criminal proceeding, legal advice will probably be that you shouldn't do that, because a criminal proceeding obviously carries even more significant consequences than a school disciplinary proceeding. So if you think there's a chance that there is criminal prosecution that might be happening at the same time as a school disciplinary proceeding, definitely you want to speak to a lawyer to figure out whether you can participate in the school hearing without harming yourself in the criminal process. Some schools do have hearings for these disciplinary cases where there's a panel or a single administrator that you go before and present your case, and witnesses come and present what they've seen. Sometimes you're allowed to be there when the witnesses testify, sometimes you're not. It depends entirely on the school. And you want to prepare for that. You want to think about how you present yourself, your tone, whether you're arguing you didn't do it, or whether you're arguing, or whether the evidence is such that, you need to explain some context or some mitigation for why they should not punish you in a harsh way, even though you may have violated a school rule. And you want to make sure that everything you submit in these proceedings, your evidence, if you have made written statements or had an informal interview with a dean before the more formal proceeding, is consistent. Because the easiest way for a school to just find you responsible is to just say, well, this person's not credible. They contradicted themselves. The timing doesn't line up on the timestamps on the text don't match what they said in their statement, and that will undermine your case. Most schools offer an appeal in very limited circumstances, usually if there's been a procedural error. So if the school hasn't followed its own policy or procedures, or if you discover new evidence after the proceeding's over that you could not have gotten at the time of the proceeding. Those are done in writing. There's no hearing on the appeals, and it's always harder to get a decision changed once they've just committed to a decision than it is to try to prevent it from happening in the first place. So I would not count on appeals to change the outcome in many cases. In terms of the consequences of school disciplinary proceedings, most schools will not let you graduate with an open disciplinary case. That is a real problem for cases that are starting right about now in the semester, because these cases can take a while to process. Usually if it's not Title IX related, it'll take a couple of months. Title IX cases can go on for a year, but being mindful of when you're trying to graduate and when a case is starting, and pushing things along as best you can if you think that the outcome is going to be favorable to get you graduated. If you think you're going to be suspended or expelled, you may want to try to slow things down so you finish your semester and don't lose the work by being kicked out halfway through the semester. If you don't graduate because of a disciplinary matter, you will usually be conferred your degree on the next conferral date after the process is done, assuming you're not suspended or expelled. Most schools have a May, a November, a February, and sometimes an August conferral date. In terms of your future and your disciplinary record from college or graduate school, there are times when you are required to self-disclose school discipline, often on graduate school or any other academic application. In professions that require licensing, like law, medicine, psychology, and pharmacy, often you have to self-disclose when you are trying to join those professions. Most jobs do not ask questions about school discipline, but if you are working for the government or in certain financial sectors where you are subjected to an FBI background check, these things will come up. And I think the most important advice I can give on that is, if you have a school disciplinary record, do not try to lie about it or conceal it. The cover-up is always worse than the crime. Your employer or your graduate school or whoever it is will inevitably find out at some point. And I have seen many students get kicked out of graduate programs, not necessarily because they had college discipline, but because they lied about it on their applications. And then I think Christina is going to talk about what do you do after you've been through a disciplinary process at school, or what other actions can you take against your school. The OCR process that Christina will talk about is one way you can challenge discipline if you think that the discipline has been meted out in a discriminatory way. You can also sue your school if the school doesn't follow its own policies or procedures, or if they have discriminated against you on the basis of a protected category in using those policies and procedures. And at public schools, you have your free speech rights under the Massachusetts and federal constitution. And so you may have claims arising out of the school depriving you of those rights. So there are sometimes remedies when the school gets it wrong in a disciplinary process, but it can take litigation to fix that. Thanks.
Great. Thank you so much, Naomi. I just want to make sure people saw that Fatuma just posted a new Know Your Rights leaflet that's based primarily on information from Naomi and Jeff. So you're getting it from the best sources. So, and that also includes how you can get a list of attorneys if you want to hire someone by going through either the National Lawyers Guild or through our office, CARE Massachusetts. Our fourth speaker is Anika Akaraju. Anika is a junior at Boston University. My voice is going to be completely gone by the end of this program. Sorry, where she is the creative director of BU's chapter of Students for Justice in Palestine. Anika, can I also just tell people that you're a talented artist and have a sculpture exhibit that just opened tonight, right? So anyway, We'll talk about that another time. For tonight, we wanted to hear about this great project that you came up with to track these hearings.
Thank you so much, Barbara. Yeah, I actually didn't come up with it myself. It was a joint effort between me and Professor Reza, who is a law professor at my school, who heard that we were all going through this and was like, you cannot be all doing this completely separately, which was completely true. My section is generally a plea for professors to get in touch with their students, and if you're a student, please get in touch with your other students and know who is facing disciplinary action and for what. Generally, I've seen two main categories. One is off for like facing disciplinary action for off-campus protests, and also facing action for on-campus protests. And on-campus protests, I've seen people facing disciplinary action for big use of space and breaking rules, or for speech. In the case of MIT, they're being charged with stuff like anti-Semitism and harassment for the speech that, and also like intimidation for the what they're saying in their protests. And that's also the case for a couple other schools that I'm in touch with. So at BU, I know all of the students who are facing charges, and at MIT, who I'm also in contact with, they also have a group chat for the people who are facing charges. I also put together a form, and you can see the link in the chat, where I'm asking students who I'm in touch with to fill out that form, just so we can know like what people are charged with, basic information, nothing that is incriminating, but like what they're accusing you of, when your dates are, if you have legal representation, and especially for those who have already gone through this process, what the outcomes look like. Because we want to be able to share information. Generally, what me and the students who I've talked to have felt, and when facing these school sanctions, is we've felt overwhelmed by the number of charges being put against us, especially in the case of some of the other schools that I've talked to, where they're getting hit with like charge after charge after charge. And it's felt manipulative, because we aren't necessarily entitled to due process. We aren't necessarily even getting the police reports if a police report is available for that case that the school is charging people for. So myself and Professor Reza, the way that we feel is best to combat this is to share information and know exactly what people are facing, what's been done about it, and then we don't have to reinvent the wheel every time. And it's not necessarily going to be the same as previous speakers have talked about. It's very different from school to school. Naomi said that they often don't want lawyers at these disciplinary proceedings. I know at my school we're allowed to have lawyers, but yeah, I know it's different for each school. But generally knowing how to approach the faculty, how to approach admin, how people have approached admin in the past, I think is very helpful for students at the who are facing stuff from stuff like flyering to facing disciplinary action for charges brought against them by outside police forces. And yeah, so they can kind of share strategies. Also, I want to stress the importance of faculty and the importance of faculty getting in touch with students and being able to kind of step up and help students who are facing these issues. The faculty have institutional knowledge, and they have actual institutional standing, unlike the students. So they're able to send letters in advance of meetings to people like the dean of students. It's a question of who exactly you're going to want to send these letters to, because at a different school they were charged with I think intimidation for sending for faculty sending letters to the person who was conducting these hearings for the students. Sending letters advocating for the students' free speech was seen as intimidation, something like that. Forgive me for not remembering the exact wording. But yeah, thinking about who to send that to, maybe someone higher up, like dean of students. And also, at my school, they're organizing solidarity walks, so a bunch of professors will come and walk the student to their meeting with judicial affairs, to kind of show that the faculty are seeing what's happening. Also, faculty can have meetings, right, with the dean of students, with other admin, outside of these proceedings, essentially letting them know, like, that they're not going to get rest about free speech, that the admin will get rest about free speech. And also at MIT, a student was able to get an extension on a response to a report on, like, for one of these proceedings, because of the faculty advocating for them. Yeah. And okay, so next is my plan for world domination. Generally, what I hope every college can have in terms of facing these sanctions against students, and how best I believe students can fight against that. I think every school should have a point person for disciplinary action, a student and faculty point person. So I know every person in my school who is facing disciplinary action. I know what their charges are. I know, like, what interactions that they have with the police. And there's another faculty who knows all of this as well. And also, ideally, every college will have a rainbow coalition, as a friend of mine said, of faculty who can support the students and advocate for students' free speech generally. So that means also going to these disciplinary meetings with the students, because we all know that no student should have to do this alone, and really no student, I don't think any student should have to hire a lawyer when it comes to these free speech actions, when it comes to protests and stuff like that against the school, because I mean, it would be ideal if the students could get legal support, but I know for the people who I organize with, they're not necessarily in a position to be hiring a lawyer themselves, and often we can fundraise as much as we can, but I've seen schools give 20 different people sanctions for stuff like flyering, for stuff like protesting. And like, that's just not sustainable or possible for a lot of these students. So, and also I saw that Jeff said that National Lawyers Guild can help people prepare for disciplinary meetings, but I know, I love National Lawyers Guild, but I know that they're busy people. So, having a group of faculty who are trained, who know how these proceedings go about, and who know kind of what the strategies have been, who can go and help the students, advise them during these meetings, take detailed notes, and advocate for the students while they're facing these sanctions, I think is really, really important. And I think that's the way that we can kind of communally help each other, keep each other safe from these sanctions. Oh God, thank you so much for having me.
Thank you, Anika, for having your finger on the pulse of what's going on at the many other schools. On our wish list, if we get time and energy, would be to create some sort of training for faculty members to do exactly what you're saying, so that they know how to do these things, and you have a point person on each campus. So maybe we'll get to that point, because you're right, it's a great idea. So our fifth speaker Joining us from Texas this evening is Christina Jump. Christina brings nearly 30 years of litigation experience to her role as the Civil Litigation Department head for the legal division of the Muslim Legal Fund of America. She represents clients in a full range of litigation needs, from administrative hearings through U.S. Supreme Court petitions, and argues in federal district courts across the nation. Attorney Jump has presented oral arguments in 9 of the 12 federal circuit courts of appeals. Christina, we are so excited to have you finishing things up by talking about flipping the situation to students taking action against their colleges. So you get to end things on a more, a high note.
I do. I get to talk about the things that go well, hopefully. So, or at least where students can regain a sense of control and a little bit of action to be able to do. So I do want to, I've got a brief PowerPoint here to go along with. If you can bring it to the next slide, that'd be great. That's just our cover sheet. So here we go. So I want to talk about Title VI complaints and what students need to know before they file. And if we can go to the next one, that'd be great. A little bit about Title VI in background, and I know that Naomi talked about some of this already. So I just want to give an overview here that Title VI is a little different than for those of you who maybe, for example, work with Title VII discrimination claims. Title VI comes at it from a slightly different point of view. It protects students that are in any kind of program receiving federal assistance from discrimination and harassment, and that can be based on race, color, and national origin. Historically, until very recently, it has been deemed that, or had been deemed that Title VI did not explicitly state, and it does not explicitly state religion. And so therefore, a lot of people interpreted, a lot of courts even interpreted Title VI as not addressing religious discrimination, not being something that would cover that or speak to that. In order to clarify that, on November 7th of last year, so just a few months ago, the Department of Education put out a Dear Colleague letter clarifying that shared ancestry and shared ethnic characteristics are considered to be part of race, color, and national origin, and that includes shared religion. So a shared ancestry, shared heritage, shared ethnic characteristics includes religion. And this Dear Colleague letter, which is posted on the Department of Education's website, and I believe that the links will get it to, if you go to the Department of Education's website, the links will take you to the Office for Civil Rights, or at least it's very near there, that states that the DOE wanted to remind all schools, public or private, that it is your legal obligation under Title VI to address prohibited discrimination against students and any others on campus. That would include employees on campus, including those who are perceived, who are or are perceived to be. So you don't even have to be of these religions. You just have to, like if somebody sees you and presumes that you are one of these protected religions, to be Jewish, Israeli, Muslim, Arab, or Palestinian, explicitly stating that those are covered. And in some quarterly calls that we have with the Department of Justice and some other government agency attorneys, and along with, not just with us, I don't mean to imply that it's just us that they have them with, but I know a lot of the other individuals, presenters here as well, partake in those. And those are with other organizations that work for civil rights and other nonprofit organizations. The Department of Education specifically asked for more complaints so that its numbers will be more reflective of the situation that is in fact actually happening. So if we could go to the next slide, please. So one of the questions that we get, and I will back up just a tiny bit to say that, which we'll cover in a little bit as well, but that we have taken on representation of more than a dozen students at Harvard who have been targeted, and we filed a complaint with the Department of Education on behalf of those students. And one of the questions that we keep getting a lot is, why didn't we just file a lawsuit? Why haven't we made public what our complaint is? Well, there's several reasons for that. One of which for filing the Department of Education complaint is that a Title VI complaint has a lower threshold to start an investigation. The Department of Education has pretty broad authority within this administrative context to begin an investigation. And if anything comes up mid-investigation, even if it wasn't part of the original complaint, then they have the authority to act on what they find. So unlike, for example, an EEOC charge under Title VII, where if it's not explicitly stated in the charge, then unless it's to the very high level of qualifying as an administrator's charge that the EEOC might bring itself, which is very rare, the Department of Education can do that based on any fact that it uncovers during the course of its investigation. Also, I know a lot of us litigating in the civil rights context have been frustrated with the Supreme Court's slightly waffling back and forth, very high, then forgiving standing interpretation of who has a right to bring a complaint, who has a right to bring a lawsuit. And in the Department of Education administrative context for these Title VI complaints, that is not an issue at all. So not only do the students who are affected have a right to bring it, their legal representatives can bring it on their behalf. Anybody who saw something and didn't like what they saw can bring it. And in fact, there is one very prolific filer who doesn't know any of the students at all, doesn't know any of the people who are affected. Every time he sees a news article that he believes represents a violation of Title VI at any campus, he will file a DOE complaint and refer to the facts of the newspaper article that he saw or the publication that he saw. I wouldn't recommend going that far. I do think that that strains credibility a bit, but it does get them filed and they are allowed to be filed that way. Does not mean that the Department of Education Office of Civil Rights will necessarily open an investigation on each one. They don't have to open an investigation on every complaint that they receive. They will do a preliminary evaluation of each one. They will look to see if either the individual affected has made a colorable enough claim, roughly equivalent, but a lesser standard, but roughly equivalent to like a motion to dismiss, except again, much lower level. But just looking for whether there is some type of colorable claim, there could be a violation there. There could be something that's covered. Then the Department of Education can choose to open a complaint and begin its investigation. Open its investigation, open an investigation and begin investigating in response to a complaint that was filed. So for that prolific filer who is responding to every news article that he sees, that's not necessarily happening. Not every complaint that's filed is getting an investigation into it. However, it is that forgiving of a process, that much of an open door for at least filing a complaint and being able to file it without it automatically being kicked out. They will look at it, they will evaluate it, and they will see if there's anything there that piques their interest or that they think may rise to the level of a violation that warrants further investigation. So once that happens, the school has to cooperate in an Office of Civil Rights investigation opened through the Department of Education. They don't have a choice but to do that. The I guess like death sentence penalty equivalent would be that they then lose their federal funding if they don't cooperate. And then nobody wants to do that. And they also don't want it to be, they don't want to be known as the school that refused to cooperate with the overseeing government agency. The school cannot choose to dismiss a complaint that's filed with the Department of Education. That's one thing that we found key with our situation, because many of the students that we represent, and again, it's a confidential process, so we haven't named them and they have not named themselves. They've gotten more than enough attention already, and so we haven't gone through and specifically named them. There may come a time where that's appropriate, but it's not now. But many of them had filed complaints through Harvard's on-site processes, on-campus processes, and they were either just simply not investigated or very quickly dismissed with only a cursory or facial investigation at best, and really not much looking into it. That's not the case with the Department of Education complaints being filed, and particularly if the Office of Civil Rights chooses to open an investigation into that complaint, the school doesn't have the ability to do that. They can't dismiss it because you didn't go through quite the proper procedural process, because they just don't want to give an explanation as to why they just choose to dismiss it. They can't do that. And the Department of Education also can compel action, and it can issue penalties to the schools as a result of its filing. So it can, again, the most severe punishment would be to take away some federal funding. That doesn't happen very often. But what the Department of Education can do is compel that there be a legitimate process created. There be training provided to, for example, professors, so that they know how to deal with things that they may see and hear within their classrooms, so that the professors know what's appropriate and not appropriate to say, for starters, and so that students know where they can go. And it's widely publicized as to where they can go, who they can go to, in order to get help if they need it, if they want somebody to walk them to their classes, if they don't feel safe, who can they reach out to? What situations, what structures are available for them? That's something that the Department of Education can compel and can require the schools to create. And let's go to the next slide, please. Okay, so I do want to talk a bit about our complaint against Harvard. Again, we haven't made much, if anything, of it public. We've been general in the portions of it that we've discussed with reporters and even with other attorneys, that we are willing to talk about. And not because we're trying to be all kinds of cagey, but again, because like I said, one of the reasons we chose this process is for the protection of the students. And because they've gotten more than enough unwanted attention as it is, the students actually want to see change. And this is one of the fastest ways that we can get it. So those are two of the headlines that came out right after we put out our press release that we had filed this complaint. We represent over a dozen. The exact number was fluctuating a bit based on those who wanted to actively participate versus those who are afraid to actively participate for understandable reasons. And so it is over a dozen. We're just going to leave the number at that publicly. And they are Palestinian, Arab, Muslim, allied students, and some who are perceived to be, so affiliated students. And all of that is covered by Title VI. So all of that is a valid basis for a complaint. The students have reported a wide range of types of harassment. Some of it includes doxing, threats on campus, threats by classmates, threats or harassment by faculty, staff, sometimes donors, alumni, and strangers, but on campus. We can say that the Department of Education, the Office of Civil Rights, very quickly opened an investigation into our complaint and has informed us that it's because they saw more than a sufficient showing systemic problems. So they are investigating systemic issues at Harvard, as well as some of the specific factual examples that we gave regarding particular students. And I will say that in our complaint, we designated the students as student 1, student 2, student 3. We did not use their names in the complaint. As the investigation proceeds, as may be necessary, the students are aware that they may need to cooperate. The Department of Education, Office of Civil Rights may want to speak to some of them to get additional details. Some of it they can figure out. Some of it they can get the information by what they've requested from Harvard. And that is the stage where we are right now, is that they have already requested a wide range of information from Harvard. And Harvard is having to respond back to the Department of Education. What this does is, again, it gives the students some more power back. It gives them the ability to find more of a neutral fact finder, somebody who will actually investigate, who isn't invested in the outcome necessarily. I mean, the Office of Civil Rights is invested to the extent that it wants to see a good outcome. It wants to see the right and legal outcome. But unlike, say, an internal investigation conducted by a school that's being accused of wrongdoing, the school doesn't want to necessarily find that it committed any wrongdoing. And that's not the case when the Office of Civil Rights is conducting the investigation. They can look at it as outsiders, as neutral observers, and determine what they need to know, where they see that there's a problem, whether it's systemic or individual, what should have happened. This helps to counterbalance as well some of the one-sided media that we've seen coming out. There were a lot of complaints. There's a lot of information being put out about anti-Semitism on the campus, anti-Semitism specifically at Harvard in particular. And our complaint does not in any way, shape, or form, I can tell you, as we've said to news reporters as well, that our complaint does not say that didn't happen. Our complaint doesn't say those students are wrong. What we actually are saying is that we know the facts regarding our students. We know the situations regarding our clients, and we talk about them, and they talk about what happened to them. And then if there is also discrimination occurring for another minority religious group of students, then to us, that just shows an across-the-board failure by the university to protect its students and to take action and to, quite frankly, know the right thing to do and be willing to do it. So that's the approach that we're taking. It's not one versus the other, but knowing that and having the neutral framework that the Department of Education opened an investigation and did so in under a week from when we filed this is something that is now made public. The Department of Education puts that on its website for any open investigations that it has. That does help, I think. It helps to show that there's more than one side to the narrative, and it is getting out there in public, and you can see there are some headlines as well on that. And also the Department of Education, with that Dear Colleague letter, with some of the speeches that have been given, with some of the trainings and informational subject matter that's been put out by the Department of Education and the Office of Civil Rights, they are asking for complaints, not because they want people to make it up or to go get any one particular school, anything like that. It's not that, but they're hearing general feedback from the communities that this is a widespread problem. They want the complaints so they can show that it's a widespread problem. And they want the complaints so that they can show how widespread and who it's affecting. One of the situations, again, as I mentioned earlier, if there's an individual who's just filing every possible complaint for any headline he reads that speaks to how Jewish students may be treated unfairly, that particular individual files anti-Semitism complaints, then the numbers are skewed. And that's why the situations, like you've heard from other speakers, are so valuable. We can keep track. I know CARE has done a good job of that as well. In addition to, you heard about the algorithm for keeping track of complaints and incidents. Those are very valuable. And that's what the Department of Education is asking for, is to help it be able to present more balanced information, more balanced statistics, and to be able to take more balanced actions. And so if we can go to the next slide too, we'll talk a little bit more. Okay, so again, I don't want to get into too much detail about the students in particular. As I said, it is a confidential process. We are using the confidential process to provide these students a break, to give them a little bit of a breathing room. There have been doxing trucks all over Harvard for months. It's not just that. Some of the situations, generally speaking, again, are that students are being harassed on their way to class and from class. And while they're working their on-campus jobs, they're being harassed and called terrorists simply because they're walking around wearing keffiyehs on campus. Other students are saying, I feel unsafe because that individual is here. Well, that individual is another student who somebody claiming to feel unsafe by their presence is simply judging them based on how they look or what they may be wearing. And another thing to bear in mind with Title VI, it's not just simply that these acts happen that we need to show, that the Department of Education will need to show in order to take action. It is that the university, the school, the whatever facility failed to act once it knew. We believe that that's going to be a pretty easy bar for us to meet. We think that we did meet it. And apparently the Department of Education believes that there's at least enough information to make a strong showing that's worth looking into from what we provided based on the efforts that our clients made and that didn't get them anywhere. But bear in mind that the focus is not necessarily, did the wrong act occur? Were the discriminatory words spoken? Did the discriminatory or harassing activity take place? It's not just that, it's did the school know? And did they fail to act? So this is focused on their burden, on what they should do, what their responsibility is to the students, to protect them, to provide a safe place to learn. And again, we feel really confident that they most certainly have not done that. And we think the evidence will show that. Not to sound too lawyerly, but we think the evidence will really clearly show that. And we're glad to be able to help these students in providing them a safe way to bring these claims into a neutral, more objective forum. So that's what I had right here. I know we do have some time for not complaints, for questions. So I don't want to take up all of the time or keep people too late, but those are the basics that I wanted to get. The pictures here, that's our civil litigation team at the legal division within MLFA. Actually, I could take the incoming off there now. Jinan Shahade actually has arrived and is watching. Hi, Jinan. And we're glad to have her. So she is our third civil litigation junior staff attorney within the civil litigation department that we have.
Thank you, excuse me, so very much. Tahira, you're going to take over now for question and answer, I believe. You're muted.
Sure thing. What a vibrant and important conversation. And I hope that people saw not just the value in the sharing of information, but also maybe some validation in what we've been experiencing over the past 4 or 5 months, and to hear people come together and put actual names and concepts behind the things that people are experiencing, many of us having heard of these things for the first time. It feels, it just feels like it makes us more complete. And I say, as a practitioner and someone who aims to protect individuals, even I needed that, right? Even if I'm not actually impacted by the harsh punishment and what have you, to hear that people are thinking about it and talking about it in this way shows that we're in community with other protectors. So there are some questions. I don't see necessarily that they identify who they're directed to, so I'll form the questions, and you can speak up if you think this is something that's within your wheelhouse. So one question is, can you address the distinction between university police and the quote regular police, i.e. the town, city, or state law enforcement agencies? And does an arrest by university police have the same consequences? Jeff, did you answer that one already?
Yes, I did.
Okay. Do you, I don't know how visible the questions are to everybody, but if you don't mind just giving us a quick verbal blurb, just in case others can't see the questions.
Sure. So most college and university police have the same exact powers as regular police officers, except that their jurisdiction is limited to the property of the university or college, including the roads or streets that go through it. So they have the same power and authority. They can arrest people and bring complaints to the district attorney for people to be prosecuted. They're not rent-a-cops. They're not just security guards. They are like regular police. And in some instances, an arrest by university or college police will carry more weight within the college in terms of students facing disciplinary actions, because there's always an institutional imperative to protect the college and to protect the university, and they may be more believable to college administrators than outside police who are trying to impose discipline or trying to impose something onto a college. So in some instances that will have a greater effect in the disciplinary proceedings than it will in the court proceedings. But generally they have the same powers to arrest, and the same consequences flow from that.
Thank you. I remember being in law school orientation and being told something similar. And I think all of us coming in that year were really shocked by that fact, but it's good to know. I see that some of the questions have been answered in the chat. I want to emphasize a question, Jeff, I think you answered this one as well. This is, does the National Lawyers Guild support or represent individuals carrying pro-Palestinian demonstrations that are not representing any organization or school? I know you answered it here. Do you mind just telling us what that answer is?
Sure. So the Guild is a volunteer organization. So we have lots of volunteer lawyers, and we have a volunteer mass defense committee. We are happy to help people planning demonstrations. We can provide training for people to become legal observers. We can provide training for demonstrations, the legal consequences of what people are planning. We generally provide free representation to people who get arrested, at least at their arraignment, and in most cases can provide free representation all the way through a case. It depends on the availability of our volunteers because, as I said, everybody has full-time jobs and working, but the volunteer attorneys for the Mass Defense Committee are committed to protecting people's rights in progressive activists, pro-Palestinian people. And so we're available to do that. The more notice we can get of an event, of a planned demonstration, a planned direct action, or a court appearance, obviously the better, because we're all volunteers.
Well, we appreciate you. We appreciate everyone who's working towards this cause.
And all our services are free. There's no charge for any of our services.
Thank you. All right, panelists, Barb, Fatuma, are there any other questions that I've missed?
Yes, there's a lot of new questions that came in the open section. If we can answer those first.
I see them here.
Answered ones later, maybe.
Okay. Let's see. On the current topic, MIT students were advised they needed to report to the DEI office because the office was getting complaints from the other side at a ratio of 10-1 and even 20-1. I don't see that there's necessarily a question there.
And say that I think, I'm sorry, that I think that matches with the feedback that we're getting from the Department of Education as well.
Okay.
And also generally what's visible, I think, from, you know, a lot of the widely publicized, more generally orchestrated news reports. I'm not saying that they aren't true. I'm just saying that I think that they are made more public, made more visible a lot of times with some other complaints for other groups. And so that's a lot of what the call to action has been that I've seen and heard. And that's why I was so pleased to hear, you know, from Annika's presentation as well, that, you know, gathering the information and making it known is really important. You know, we have a lot of times we'll get from our clients, we represent everyone for free as well. We are limited only by our resources as are most nonprofits and our capacity. But we, you know, what we hear a lot is, well, I'm having these problems. These are the things that are happening to me. And they are as significant, if not more, than other complaints, which are being widely publicized and made known. But we have individuals who say, but yeah, I don't want to make a fuss. I don't want to draw more attention to myself. I'm concerned about it. I don't want to do something that will shed an even more negative light on me, or maybe I should just figure out how to deal with this myself. It's just not a cultural default really to raise our hand and complain. And we're fighting a little bit against that in order to be able to utilize the protections that are there.
For sure.
Yeah,
For sure.
If I may, that's also something that we're doing at my school, at least. We also have an incident report log for people to report, at least to us, share with our group, like what they've been facing. A lot of students, especially in the month of October, we're facing death threats, stuff like that, for being vocally pro-Palestine. And that's something where we can kind of collect that information and we can bring it to our school as a group rather than having to have individuals go to admin.
Thank you. There's a question here, and it's, is there a step-by-step guide of action for students such as Muslim students on campus in Massachusetts, maybe through the Muslim Student Associations if they do need legal support, or a couple of points of contact, as sometimes despite following their school's code of conduct, they still may not be supported? Is there such a cheat sheet of sorts or reference guide of sorts that you all know of?
So the National Lawyers Guild does do direct action training for people planning demonstrations. It's about a 2-hour training for that, which is free. And I think all of the panelists here are available to provide support around particular incidences. But given that the campuses are so different and the way administrations react is very different, I don't think there's any one overall guide or step-by-step guide about that. I think it depends upon what legal issues or disciplinary issues are being raised and what kind of support they have on the particular campus among faculty and other students. There's no one size that fits all.
Understood. And things are so dynamic in terms of what we're facing today that I imagine that each scenario needs to be analyzed based on the facts of the person experiencing it. Someone has a really good question. So if there's outreach by local police departments and the FBI to students and mosques to see how they can help and support, should Muslim students or Muslim organizations partake in these meetings? And if they do, what should they keep in mind in order to protect the rights of the community?
I think Naomi should answer this.
I think Jeff already answered this, which was don't talk to the police or FBI if you do not have to. So I think that is the best way to protect your rights in your community, is to avoid contact with law enforcement whenever possible.
I would say that
outreach, even samosas and tea.
I would add that if you feel that you want to get awareness out there to the public, then do something like bring an attorney with you to share that information. Because again, law enforcement's going to act completely differently when they know that there's an attorney in the room. And also don't say anything in that context that you wouldn't be okay with being on the evening news. Or being in an affidavit that could potentially be used against you at a later date. You can still do it, but do it with great caution.
We often see a phenomena where people get in the same room with those who are in, positions of authority, and they sort of feel flattered by that, and they want to talk, about things, and they want to talk about their friends and neighbors, and all you're going to do is create problems for people, yourself included. It's like this information goes into this gigantic pot of data. It's like what Jeff was talking about with the fusion centers. I sometimes half jokingly refer to it as that they're data addicts. They just want it. And then they're going to put it in a big pot. And when you've got enough random facts, you can maybe make those look like there's a problem. So as a form of self-protection, we would recommend not doing that. Although there are folks who do find some satisfaction, but I think they harm themselves too often, and they certainly can harm other people who weren't consulted.
Yeah, I will just echo what everyone has said. You do not want to let the police, you do not want the FBI in your organizing space. The only time I would say you want to be talking to the police is if the police are doing like a PR thing. Like I've seen them, like for example, during a lot of the Black Lives Matter protests, police would hold like a press event where they would say like, we're so great, we're the best police department in the US, and we're so supportive. When people show up at those, when you go into their space and you can say like, you can call them out about like, well, what about this case? What about these, times when police have killed people and you have not followed up on it? Like, what about that? Like, I think that to me can be effective. Like, if you want to call the police out when they're in their space, I think that is fine, but do not let them into your organizing space.
Great. Another question for unregistered pro-Palestine groups on campus. What are some of the biggest risks when planning demonstrations? Recognizing this, of course, may vary by school, but just wanted to ask in case anyone has experience with it, is one of the questions that was posted.
I will just say that student groups being unregistered is like the low-hanging fruit for college, for administrations to bring disciplinary actions, right? So they don't have to find a specific rule you broke. You can just say like, well, you're not a student group, therefore everything you do is wrong. Definitely, the problem is that puts a lot of power in the hands of the administration because they can basically ban a particular viewpoint by refusing to recognize student groups that engage in that. So I think I have seen that used I've seen that used very frequently in the last several months as an excuse for disciplinary action.
Appreciate that.
Also,
Fatuma, go ahead.
Sorry, if I could add on to that. Also, pro tip for student organizing: if the administration isn't allowing your group to book events, stuff like that, make friends, get other student organizations to book rooms, to hold these protests, stuff like that. You can organize with them and have their name on it. That's something that we do, even though we're registered. There's only so much that our group can do, and so we have our coalition partners help us out. I recommend.
Thank you. And just to see a final question, I think this will be the final question, unless any of our panelists want to elaborate or bring up other points. The question is, how harmful can Twitter or TikTok reposts and comments be? I do know we discussed some of that, but this viewer is asking for a little elaboration, please.
Yeah, I can say, in terms of harmful, in terms of like bringing in like legal liability for yourself, like it's rare for a Twitter or any social media post to constitute like an actionable criminal offense on its own. Like there's a pretty high bar for criminal harassment or stalking that is rarely crossed on social media because of the fact that it has to be directly targeted and happen at least 3 times, at least in Massachusetts. And I don't know of any case that says just like liking or reposting something can be the basis for criminal liability. So from the criminal liability point of view, I think not very strong. From the sort of like personal safety, like will you be harassed for liking something or commenting on something? You're really taking a risk there because, you can post on hundreds of things and no one will notice. But if one of those happens to go viral, then you can really get slammed. And I've seen students who just had the misfortune of writing a supportive comment on a post that then went viral. And, the next thing they know, they are literally in a Fox News segment. So that is really unfortunate. But I will leave it to the other experts to talk about how that factors into disciplinary hearings.
I will add that I think I agree that, that kind of a post on its own is not going to make or break any situation that will come up for you, but it's certainly not going to help. So be sure that what you're saying is something that you can back up. Don't click send when you're emotional and upset because you're not going to be able to retract it. and, you know, make sure that, I think the safest thing, and a lot of what we've advised, even to students who will contact us and say, I'm not sure that I want to take any action yet, but I just want some guidance, you know, what can I do? Because I want to use my voice, but I don't want to not be able to graduate. I don't want to, you know, be singled out. I don't want my face on the next truck. It might be anyway, and I guarantee you they're going to choose the least flattering picture they can find of you on the internet, incidentally. Great trend in that, very consistent trend there. Canary Mission and the trucks will find the least flattering picture they can of you online. But, you know, one thing to bear in mind is that if you're going to do a post, if you want to, you can still use your free speech. We're not saying don't do that, but reinforce it with a site to, for example, the United Nations and the website, and something that is a neutral publication that backs up what you're saying. So it's not just your opinion, you're quoting a government agency, you're quoting the Department of State, which ironically enough has a ton of really helpful stuff for this on its website, showing what the law is, not what policy is, but what the law is. And there's a lot of stuff that you can quote and put on there, and it's going to be a lot harder to take action against you for citing to the Department of State.
Thank you. So I'm recognizing that we are at time. And I'd like to know from Barbara and Fatuma, are there any other thoughts that we need to share that I need to know as we wind down? Or Barbara, would you like to close out the meeting?
Sure. Just two quick things. There was a question posted about how someone was treated at Logan Airport. Please go to our website, log in a complaint, and we unfortunately handle all too many complaints about travel abuses. So I would be glad, I'd be the person you'll be speaking with, and we'd be happy to do that. There's a question too about, can employers deny to hire me because I'm pro-Palestine? Yes, they can. That's the subject of an entire different conversation, but that has kept us probably as busy as any topic over the last few months. Not necessarily not getting hired, but people who are already employees and are facing discipline or termination. So to close it out, thank you enormously for all of you for participating. We know you're all busy. And again, this is all in addition to what you do in your, you know, every day. And we thank all the activists and others who tuned in today. We hope that you will take this information and spread it and amplify it among your circles, because, you know, our goal is to both strengthen the voices of pro-Palestinian activists, but also to keep you all safe and healthy. And so thank you for the role that all those who are attending can play in that effort. I think my voice has just stopped working. So.
Good night,
Thank
everyone.
you all.